Compliments of the day to you all. We are Group 29 for Commercial Law, and I'm Tabani Shonai from Group 29, and with me are my colleagues. Here is Rukuzo, I got Jenme, I got Alma, I have Nigel, and I got Kimberly. So our topic is duress and undue influence. It is worth noting, before we delve much into duress and undue influence, to highlight where these two concepts are emanating from. First of all, we need to start by defining what is a contract. With us is a definition by Chigogora, who defines a contract as a lawful agreement enforceable entered by parties of competent capacity who then comply to the elements or to the terms of such agreement. From the definition by Chigogora, it can be noted that there are certain prerequisites that should be there for there to be what? A valid contract. From there we move on to classes of contracts, in which contracts may be classified. This is when we have void contracts and voidable contracts. For the purposes of our discussion, or for us to have a clear outline of where we are going to deal with voidable contracts, in which we are going to highlight facts that vitiate a voidable contract, which will then bring us to the gist of our presentation, where we'll be dealing with duress and undue influence. At this moment, ladies and gentlemen, allow me to leave this time to the first presenter who will be dealing with the definition of duress and other presenters. I thank you.
As my colleague has already hinted on, I'm going to elucidate more on what duress is and what elements it constitutes. Okay. So duress is when one is induced into entering into a contract either by virtue of being forced, threatened, or compulsion. What constitutes a valid contract is when both parties agree to enter into a contract without being forced. When one is then forced, that contract becomes null and void because one of the requirements of the elements will be lacking. If a person is induced to conclude a contract by duress, such a person concludes the contract rather than undergo the threatened action. The threatened person is directed at the particular agreement, consensus is reached, and the contract in fact is asserted. For example, where a person physically forces the hand of the innocent party to sign a written contract, in which the case the contract will be void ab initio. However, since consent is obtained improperly, the contract is voidable. Therefore, as we have already hinted on, duress, when someone is forced to enter into a contract, that contract holds no water, it's invalid. A person who alleges duress has the honors to protest. He must show that he had no other option but to comply and give in to duress. An example of a case that was entered into through duress is the case of Broderick versus Mars. In the case, the plaintiff was forced to join the army by threats of death on his person and his family. The court had to set aside this involvement on the basis of duress.
I'm now going to explain on the elements of duress that are required for a successful claim. The requirements were clearly enunciated in the case of Mukwananzi versus Banda and 7 others. They were stated as follows. The fear must be reasonable. It must be caused by the threat of some considerable evil to the person concerned or his family. The threat must be of an imminent or inevitable evil, and lastly, the threat of intimidation must be unlawful or contrary to mores. For a party to successfully claim duress, the above requirements have to be fulfilled. R.H. Christie, in his book Business Law in Zimbabwe 2011, page 82, says the following on duress. A contract obtained for or by fear induced by threats of force obviously cannot be allowed to stand, but because of the infinitely variable nature of force, fear, and threats, the limits of this principle require careful attention. The fear must be such as would overcome the resistance of a person of ordinary fairness, taking into account the sort of person the victim is, for example, young or old women. The above clearly highlights that not all claims of duress presented before the court are acceptable unless if the plaintiff has proved all the requisites, can the relief being sought by the plaintiff be granted or awarded.
To carry on, in R&D and another versus Astra Ventures Private Limited, it was stated that it is clear that a contract may be vitiated by duress, the race of the article of the rule apparently being that intimidation or improper pressure renders the consent of the parties subject to duress not true. Consent. Duress may take the form of inflicting physical violence upon the person of a contracting party, inducing into him fear by means of threats. Contracts that are entered into involuntarily because of duress can be reversed as there was no voluntary or independent intent to enter into a contract. These cases are, however, difficult to pursue, as the onus that is placed on the plaintiff may be difficult to prove in most instances. This is explained in the case below. In Muza versus Agricultural Bank of Zimbabwe Private Limited, it was stated that contracts that are void ab initio for reasons of duress are very rare, as the duress required to render an agreement void ab initio has to be extremely severe. It has to be so severe as to negative any element of voluntariness, such as where a physically stronger person physically overcomes a weaker person and puts a pen in his hand and physically forces his hand to write his signature on a written contract.
So now I'm going to be presenting on undue influence. Undue influence is any improper or unfair conduct by one of contracting parties by means of which the other contracting party is persuaded to conclude a contract with the former contrary to the latter's independent will. The influence must weaken the other party's power of resistance and make his or her will pliable. Undue influence is not easily distinguishable from intentional misrepresentation or from duress. A court will be more readily disposed to find that undue influence has been exercised where there is a special relationship between the parties. Such a relationship is one which exists, for example, between a doctor and a patient, an attorney and a client, a guardian and a minor. If such a special relationship exists, it is relatively easy for the stronger party to abuse the situation. This may take place, for example, through the abuse of the other party's ignorance or lack of experience, physical frailty, intellectual weakness, or mental dependence on the stronger party. By taking advantage of the special relationship, the other party's will is made pliable, so that he or she is influenced to conclude a contract that would otherwise not have been concluded. If a party is persuaded through undue influence to conclude a contract, his or her will is directed at the contents of the contract, and a contract does indeed come into existence. However, the party's assent to the contract has been obtained improperly, so that his or her independence was not exercised. Thank you so much, and I will leave this time for the next presenter to be presenting on the elements of undue influence.
So we are going to be discussing the elements of duress. So we are going to use the case of Jordan versus Prila, which is a 1956 case, volume 1, South African Law Court. The appellate division held that for a party, for Jordan to prove that there has been duress, he had to prove the following. Number one, he had to prove that the party had assumed influence, which weakened his power of resistance and made his will pliable. And also the other fact that he had to prove, which is number two, is that the other party used his influence in an unscrupulous manner to persuade him to consent to transaction which is to his detriment, and which with normal free will he would not have entered. So an example of undue influence is if X, an elderly farmer who is ailing and weak, is induced by Y, his doctor, to donate a farm to Y. So these are basically two examples which exemplify the elements of undue influence. Alright, so ladies and gentlemen, thank you so much for watching this video. This was about duress and undue influence, and we are group 29. Bye bye.
Thank you.